Good afternoon, everybody. It is April 30, 2020, and today we are talking about conducting evidentiary hearings via Zoom. We had probably a record sign up today. I think a lot of attorneys are beginning to see that their future will hold in some court at some point an evidentiary hearing via Zoom. And so I can see there are a lot of judges and attorneys and referees on the line. So thank you for coming. We have a wonderful panel today. Judge Tina Yost is a circuit court judge, family division, Calhoun County. She's running a little late. I think she got stuck in a hearing. So we'll give her a chance to join us, and she has a lot of ideas to share with all of us. We also have Peter Koulis, who is an attorney at Warner Norcross, and he is on the Family Law Council with me. Oh wait, you're not on council anymore, are you, Peter? He was on the Family Law Council. That's why I originally met him. He will be again someday, I think. And then Michelle Younger is an attorney at Jaffe. Michelle Younger is an attorney at Jaffe in Oakland County. So thank you all for coming. Just to remind everybody that we do have the chat function. If you want to ask questions, that will kind of give me the heads up that you have a question, and it will give me an opportunity to call on you, and then you can unmute yourself. I once again, for like the 5th time in a row, I forgot to create a poll beforehand, even though I intended to. But I know a lot of attorneys are getting prepared for the fact that they're going to have this reality for the first time of doing an evidentiary hearing via Zoom. So thank you all for coming. So as we get started, we have a lot of topics to cover today. It's actually quite a bit to cover in 1 hour. We're going to do the best we can, but we're going to kind of organize it just so you're aware, because I know you're going to be having questions as we go along. We're going to start it with things to do before the hearing. Then we're going to move to like etiquette and preliminary matters that can be before the day of the hearing. And then we're going to get into the actual evidentiary hearing. So we're going to kind of break it down into those 3 topics. So think about your question and where it might fit. If you think it doesn't fit until the evidentiary hearing portion, if you could hold off on posting it on the chat, because it might get lost if there's a lot of chats. I might not see it at the time that we're working on that topic. So as we're getting started, I wanted to hear from our panelists about what's going on in the counties they practice, because I know there's some very divergent things happening in counties around the state. We'll go ahead and start with you, Peter.
So I primarily practice over here on the west side of the state. I do a lot of work in Kent County and Ottawa County, and I think there's a huge divide between those 2 counties currently. Ottawa County, as I mentioned for those that were on earlier, has been doing Zoom trials and evidentiary hearings and regular motion hearings since sometime in March. So they've been doing it for a while. Judge Van Allsburg has been very adamant about making sure that the docket keeps moving and moving along in an expedient fashion. I was supposed to have a trial this past Tuesday with him. That's kind of what spearheaded this conversation with me and Lisa, trying to prepare myself to ensure that I'm thinking not only about my trial, but also thinking about potential appellate issues that might come from this whole new process that we're all dealing with. And so that's what kind of happened, and that's what kind of the genesis of today's Zoom webinar. Kent County just released a new statement yesterday where they're encouraging their judges in the family division to conduct as many hearings as they can via Zoom, but it's still under the may, not a shall. So as of right now in Kent County, we can't even get a summons to start a new case without petitioning the presiding judge to get that. So we have a lot of limitations in Kent County. They are not doing settlement conferences or scheduling conferences via phone or Zoom. It varies from judge to judge, from what I've been told. The judges that I've had my cases with have all just been adjourning everything past May 15th deadline. So completely 2 different spectrums for 2 counties that are right next to each other over here on the west side.
And I see that Judge Yost was able to join us, so I'll go ahead. And Judge Yost, I already introduced you to everybody, but if you could just share what you know about Calhoun County, and if you know anything about your neighboring counties, we're welcome to hear from you on that as well.
My apologies, I switched locations. I think I was having a problem with my Wi-Fi signal. So there, as Peter explained, there's a divergence not just within between counties, but within counties. And so different judges within counties are handling things differently. I think that, you know, in my local jurisdiction, I'm in Calhoun County, we do have a division in the docket such that there's a little more consistency, but we're constantly getting questions from the clerk, you know, Judge X is doing it this way, Judge Y is doing it this way. And I think we're trying to do our best to get more of a consistency, because when this initially came out, all of us were kind of looking for direction from the Supreme Court or from our chief judges. And we were kind of told, hey, you know, these are the basic mandatory cases, set your docket, do what you want. You can do a little more, you know, this is the minimum you have to do. And so everybody kind of went their own direction instead of having more of a unified spread out. And I think that was to allow judges to manage their own docket, which is good, but at the same time, I think can be confusing for counsel that participate in multiple jurisdictions. So I would say I lean a little more towards Judge Van Allsburg. I have been very careful to reach out to Ottawa County, Kent County, Judge Minor and Bay County to try to get some consistency. So I do know that some, especially family court judges, are trying to collaborate and get more consistency, but we also have different barriers. Is your courthouse open? Is your courthouse not open? You know, do you have positive cases of COVID in your courthouse, which our neighboring jurisdiction, Jackson County, I know one of our referees from Jackson is on today, and they had some issues with positive cases over there. To my knowledge, no one in Calhoun, we've had police officers, but no one in Calhoun County in the court system has actually tested positive that we're aware of. So for personal protection order proceedings, or excuse me, for personal protection order proceedings, I'm proceeding on almost everything, unless someone requests an adjournment for good cause, and then I'll hear that. For juvenile abuse and neglect cases, I did a termination hearing this morning. We had just the right circumstances, and when I originally started this, I couldn't see myself doing termination hearings, but we had a father who was in prison who would have appeared via Polycom anyway, and all the parties kind of agreed, you know, this was a situation that we could do it. So we are trying really hard for family division matters. I've done divorce cases already. I have a divorce trial coming up. Both sides agree that they're able to present their issues. Probably the biggest, and I know we're going to get to this, the biggest issue we're having is struggling with how to get the exhibits in and make sure everybody can see them, that they're exchanged, etc. But for the most part, the only cases I cannot proceed on right now are, I have some issues with child witnesses, and I have some issues that I'm really struggling with regarding publication, because our courthouse building is closed. So if there's publication, how would I know if somebody showed up to object or somebody showed up to participate? But other than that, we're really trying to move the dockets forward because we just see that landslide at the end and people need their services. So we're doing our best to serve the community.
Thank you. And Michelle's over on the east side of the state. So Michelle, can you give us a little update about what you know in the counties that you're practicing in?
So in Wayne County, right now they have not been proceeding on any evidentiary hearings, just some motion hearings. I think some people have had hearings via Zoom, but starting May 11th, Wayne County plans on moving everything to Zoom for the foreseeable future, they said, and that involves evidentiary hearings. I know every case that I've had has been adjourned, and I've now received notices, I think, for the end of June for some of my hearings in Wayne. And in Oakland, it's been judge dependent so far. I know that front of the court is going forward with hearings, child support reviews and child support and parenting time hearings. I have a review scheduled in May. I have another hearing that we had a motion just before the court shut down, and we set a hearing date for the end of May. And I expect that to go forward. But in terms of the motions, I know we had Judge Cunningham here last week. It seems like it is still judge dependent, but they will hear them if you reach out. And
Thank you.
Primarily those.
I know we have, oh, sorry, go ahead.
No, I was going to say, those primarily, so that's where I practice. I know in Washtenaw. Can you hear me?
Yeah, you cut out for a second.
Sorry. They also have been proceeding only on emergency motions.
Right. Thank you. So I know we have several judges on the call and also people around the state who are practicing in other counties that we haven't touched base on. You're more than welcome to put something in the chat. I know Judge Krimkowski from Leelanau County has already posted about what her court is doing. And I know that the chat is available to everybody even after with the recording. So if you want to share specifically if your county is doing evidentiary hearings by Zoom, not just motion hearings. So let's just dive into it. One of the things that, as Peter and I were talking weeks and weeks ago, it really occurred to us that you have to be more prepared with your hearing if you're doing it remotely. Judge Yost, did you raise your hand?
I did. I just wanted to mention that most counties, I'm not going to say all, but most counties, if you check their website, we have posted our COVID-19 procedures. So I would encourage council, go to the website for the local judges, or if you're practicing, I have written COVID-19 procedures that I can email out to everyone that tells them what kinds of cases I'm doing and how I'm proceeding on cases. We're trying to get something put together on how to put exhibits in once we get a solid practice for that. So I would encourage, reach out to looking at your local website, and also judges are sharing resources so we can, again, try to be a little more consistent. So any of the judges online, if you wish to reach out, I'm happy to share any of the collaborative material that I've obtained from MJA or the other judges. And that goes for referees too.
Thank you. So getting exhibits together well in advance of the hearing is, I think we all agreed with our panelists that it's critically important to do a remote hearing. This is going to be great for appellate attorneys because I think it's going to provide an opportunity for exhibits to be all organized to put together in one place. So for my panelists, if any of you want to comment about the process of what you think is the best way to gather your exhibits for purposes of a remote hearing.
Peter, I think.
Oh,
go ahead.
I think you really have to have your exhibit list done well in advance. Exchange it with the other side and submit them to the court. You first need to find out how the court would like you to submit those exhibits, whether it's in an email. I know Peter has something to share on that, but not all judges might want it the same way, and so you need to find out exactly how the court wants it and agree with the other side to the extent that you can. And then the most important thing is also making sure that everybody receives it and that the court receives your exhibits, because I had an issue come up where I submitted exhibits and then one of the files that I submitted was corrupted. I resent it, asked for confirmation, didn't receive that confirmation. A week later we had the hearing and it turns out it was never received. So really making sure that everything is done and is done correctly is going to be critical for efficiency.
Great. And Peter, you and I had talked about the having basically 3 sets of exhibits. Can you go ahead and share your thoughts on that?
Yeah, so when we were talking, we want to make sure, like Michelle mentioned, you're having open communication with opposing counsel about what you can or cannot stipulate to. So, I mean, I think some of the normal civility that goes along with a regular trial still is going to carry over into a Zoom trial. So you want to try and stipulate to things that you know are easily going to come in, that it's only just going to take, some basic foundational questions to get in, because again, from what I've been told from other practitioners and other judges and referees that I've talked to about this issue, is the Zoom trial is going to add time to the process. And so any way to help streamline that is just going to be a better service to your client. It's going to be a better service to the court. And it's just going to be a good, way to manage your time. So you're going to generally have the exhibits that you're going to want to admit that you couldn't get stipulated to. There's going to be a group of exhibits that are going to be stipulated to, and then you're going to obviously have opposing counsel's exhibits. And as Michelle mentioned, are you able to let me share my screen real quickly so I can show that document?
You should be able to do it now. Go ahead.
Okay. So I'm showing you guys, I've blocked out the information from the court as far as it relates to my case specifically, but here, and I'm going to maximize it, you can see that this is from Ottawa County, and it talks about specifically how to submit exhibits. And so you can see here, this is from Mary, who is Judge Van Allsburg's clerk. It tells you specifically the email address that you're going to be sending it to, so you're not making any ex parte communications with the judge. And then it tells you specifically here how they want the document titled. And so again, if it is a stipulated exhibit, I think you're still going to put the same information that's being requested here, but when you submit it, you can say that it's been stipulated to. And then it kind of gives you instructions for witnesses as well. So when you look here, you can see that they've got a P1, P2, D1, D2, depending on if you're defendant or plaintiff. they want the case number, followed by the date of your hearing, and then they give you that full example for Defendant's Exhibit 2, and the Smith v. Jones would be Smith D2, case number, date of hearing 7 April 20. So as we talked earlier, you're going to have a lot of extra prep time that's going to go into your case, and this is just one of the things that we as attorneys have to be proactive and not expect necessarily the court to send all this information out. Ideally, we would think that they would, but we all know that things slip through the cracks. This is all still fairly new territory for everybody. So I make sure when I had my hearing to be in constant communication with the judges, clerks, to find out, hey, how do I do this? How do I get the exhibits submitted on time and in a way that is acceptable for the court? So my understanding too is, and I'm not sure if we want to talk into this now or later, I guess we'll talk about it later when we talk about the actual evidentiary hearing. We'll explain how the exhibits are shared.
And Peter, for the letter you received was on April 8th for a trial that was scheduled, I think for last week. So it was at least 3 weeks in advance, I'm thinking, or 2. So if you haven't heard from your judge 2 weeks before your scheduled evidentiary hearing, I would, be proactive and reach out to the judges' chambers to find out how they want to receive those exhibits. And I also want to remind people that it probably would be very helpful to pre-mark all of them so that when you scan them in, they already have the exhibit numbers or stickers on them. So you're not trying to fumble around doing that during your evidentiary hearing. Now, I know we could spend a lot more time talking about exhibits, but before the hearing, there's quite a bit of other things to take care of. So let's move to clients and getting your client prepared for an evidentiary hearing by Zoom. Michelle or Peter?
Go ahead, Michelle.
You want to make sure your clients are set up with the correct technology, that they're able to test it out in advance and log in and they don't have issues. I think you also want to talk to them about childcare during the hearing. I don't know if the parties are still residing in the same home or they're divorced and they have the children, but making sure that the children aren't present for the hearing and figuring out who can watch them, if anyone, during the hearing. Otherwise, you may need to talk to your lawyer about seeking an adjournment, because we don't want children, obviously, to be sitting there during the hearings. And they should dress appropriately as if they were coming to court and be ready to proceed and understand what to do. Talk to them also about how to proceed if they need to reach out to you during the hearing if something comes up where they need to talk to you. You don't want to do that, obviously, through Zoom where everybody could hear and it's being recorded.
And I think one of the things, Michelle, we talked about yesterday was that if your client cannot secure childcare because of the shelter in place or whatever, you may not be able to do an evidentiary hearing. You might just have to delay it until later in time, at least when childcare could come, or the kids could be moved somewhere else, or the client could come somewhere, even if it's remote, where they can be have the children watched by somebody else if they're not in the house. Peter, did you have anything to add to that?
Yeah, just briefly, I think going along when we're talking about preparing for trial in general, you have to remember your client already has a lot of anxiety about trial and court in general. And now we're throwing into the mix this new process that a lot of us are not familiar with. It's uncharted territory. So I think it's that delicate balance of making sure that you relay to your client that they should have the confidence in you to be able to present through the hearing, but understand that this is new territory and that the court is, in my experience, will be a little lenient to some extent for smaller mishaps, but also making sure that you prepare your client to know that that monitor and that camera is on them at all times. Just like as if you're in a regular hearing, the judge might not necessarily see a puff of, whatever from a client or a slamming of the hands on the table, but that camera is on 24/7. And making sure that they're aware of that, and also making sure that they know that some counties are streaming it directly onto YouTube as the hearing is taking place. So not only do you have the eyes of the court during the hearing, but the availability of more people being able to watch this hearing is also going to be taking place. Whereas prior to this new normal, how many people really showed up to watch somebody's divorce trial or their evidentiary post-judgment matter? Probably nobody.
Right. Judge O's, could you just quickly address how it's working with the YouTube?
Yeah, so I advise every party, when I start a hearing, I initially start the parties, bring them in, I do a roll call, I check technology. Once that person is done, I ask if there's any preliminary matters with counsel that should be addressed before we go on the record, just like you normally would if you had a session in chambers. If there's a need for breakout rooms, offers for pleas, anything like that, I go ahead and put that in the breakout rooms. Then when we're ready to go on the record, I announce to everyone, we are live on YouTube. I remind them of their manners and etiquette and things that they should be doing, because I have to tell you, we're now collecting a list of funny things that have happened already, or inappropriate things that have happened already on YouTube. So it's very important. We had one attorney that the husband started walking in the background, loading dishes in the dishwasher while they were sitting at the kitchen table. And it wasn't my county, it's another county, but the judge had to, judge shared with me that they had to reprimand and say, you know, please send your husband out of the room. I can hear him loading dishes. You know, so you really have to make sure you're in a secure environment. It's not a funny process. You know, when we first started, I had an attorney show up in a Halloween mask for a divorce trial. I understand it may have been humorous to him and his client. I did not find it so humorous, because in my world, these are real court proceedings. So getting the message to your client, prepping them early is important. And I advise them, you are live on YouTube. Anyone can watch this. It's just like you're in a courtroom. And I cover that with them. I also tell them when I'm going live on YouTube, when I am going off. We have been directed that anyone can watch a proceeding on YouTube. I do not allow, and I believe most judges are not allowing third parties into the Zoom sessions. You have to go watch just like as if you were in the gallery. And we direct them to the county website. So again, next to my name and next to almost all the judges' names is a link to the live YouTube. You can click on that. I will tell you, don't think that it's going to be there to prepare your order after the fact, because we have been instructed for security purposes, and because these are mostly, our cases at least, are hearings regarding children, we are deleting those right away. So they're not remaining up on YouTube. We delete them immediately after the hearings.
So we're jumping ahead a little bit, but this is really relevant, the comments about YouTube and some questions that we're getting on the chat about how do you reconcile having a sequestered witness, and witnesses was the actual next topic that we're going to talk about, having a sequestered witness while the proceeding is being broadcast live on YouTube. How do we prevent that sequestered witness from watching the YouTube live feed? And some people are suggesting that maybe it won't be broadcast live, but I think there was an issue, Judge Yost, you can elaborate on a little bit, that the Supreme Court has ordered that all the hearings be made publicly available. I think it's been interpreted to mean during the actual proceeding.
So courts are required to be open to the public. We are not allowed to close courtrooms except under very specific rules that are addressed in the court rules. So they have been blatantly clear with us, we will broadcast these live. The only exceptions would be parental waivers. Those are confidential anyway. We would not broadcast those on YouTube, of course. Adoption hearings, I don't think are required to be broadcast, because again, those are confidential hearings. If I have a situation where I have a child witness and we have closed the courtroom under the court rules after proper motion, I do not believe I need to broadcast that live, because again, we closed the courtroom. But in any situation where the courtroom would be normally open, we are required to broadcast it live on YouTube. It's not a later thing. It's going on immediately, real time with the hearing.
So one thing, Judge Yost, would you be then telling the witnesses who are sequestered, ordering them basically not to look at any internet or anything while they're waiting for their turn to be called as a witness?
So I had a termination trial this morning, and I went over rules with the witnesses right in the beginning, and I questioned each witness. So after I swore them in and they're under oath, I question them, and I give all the attorneys an opportunity to question them. You know, we can't stop people from talking in the hall either, right? So what's the difference between somebody walking in the hall and having a conversation with someone who was in the courtroom and someone watching the YouTube? We warn them they shouldn't. Somebody's going to violate. If they do, that witness can be stricken. You make your proper motion. But I think it's important to question them under oath. So for example, this morning, I asked them, did they have any papers or anything in front of them, any notes to rely on? The witness responded, yes. I said, you're going to need to remove those. The second question, and I offered them the refresher memory if they needed them. The second question I asked them was anyone else in the room? And they said no. And I said, you understand that you have an obligation to remain in this room by yourself without being in view of somebody else to influence your testimony during your questioning. They responded yes. And then of course, the third question would be, you know, have you talked to anybody about these proceedings or watched any electronic recordings, or have you watched this proceeding? Now, if witnesses aren't sequestered, you don't have that problem. But if there's a motion for sequestration right in the beginning, again, it's just like anything else. Attorneys are ordered to consult with their witnesses and tell them there's likely to be a sequestration order. You're going to need to not watch this, or you could be prevented from testifying. No different than any other case. I really don't see that as a problem. It's just one more avenue they can possibly get information. But if they wanted it in a real trial, they'd go in the hall and do it too.
And I think that's where it comes back to a little more of that before the hearing preparation of making sure, and this is one of the next things I think we were going to start talking about, was the subpoena. And when we have our witnesses subpoenaed to this hearing, is we need to make sure that they're all they are right at the beginning, so they can get the instruction from the court that they're not supposed to be watching the YouTube live stream. Specifically, even if they're not going to be the first one that you're calling to testify, they need to be part of the court proceeding to hear that instruction from the judge. Otherwise, there's no way to hold them in contempt or hold them accountable for watching it. So I think it's one of those additional conversations that us as practitioners need to have, not only with our clients, but with our potential witnesses, that yes, you're going to have to show up at 1:30 when the case is called and started. There's a chance you'll be sequestered, explaining what that means, because most of the time people don't know what that means, and let them know that they're going to get an instruction from the judge. And then it's, in my experience and the people that I've talked to, it's going to be dependent on the judge whether they're going to then put that witness in one of the waiting rooms of Zoom, or they'll allow the witness to then come back at a later time. It really depends on the judge, but I think you need to have all of your witnesses available right at the beginning of the hearing, so that way they can hear that instruction from the court, so that way they can be held accountable.
Judge Yost?
I think it's very important for counsel to clarify how that's being done, and for the judges and referees on the line. We tested this yesterday. If they're in the waiting room, they cannot talk. If they're in the same breakout room, they can talk. So if witnesses are sequestered, they should not be placed in the same breakout room. So you're going to want to ensure how that process is done.
Michelle, do you have anything to add about witnesses?
I think it goes back to, we hope, like Judge Yo said, some people will violate the rules and we will have to deal with that, because even if you put them in different breakout rooms or in the waiting room, of course, they're not in this box of Zoom, and they could pick up their phones and call other people, and we can't really prevent that, but we have to all be aware of it.
Thank you. So we're going to move now to some preliminary matters and etiquette. I know we've sort of touched on some of these issues already.
Lisa, can I backtrack for one quick second on the subpoena component? I'm sorry. So I just wanted to mention that when you do your subpoenas for your witnesses, because I was wondering about this, what do I put down for the location of where they're supposed to appear? And so the instruction I received is you're still going to put the address of the court, but you're also going to put down in the other, you're either going to say see attached A, and then you're going to attach a separate document to your subpoena, just as if you're doing a request for production of documents that has a laundry list of stuff that you can't necessarily fit on the subpoena. You're going to put on that document the Zoom information that the witness is going to need. I also go the next step and include with my subpoena a letter to the witness, and usually I've already talked to them ahead of time, but I put in that letter too, just so I have some written confirmation to go along with it, that says, if you have issues, you cannot connect via internet, you have internet issues, cell phone issues, you're up north where you're relying on satellite that's not reliable, please contact me immediately. So that way you as a practitioner can address that to the court, say, Your Honor, I have this witness, that they can't appear via this because of this, yada, yada, and go from there as far as what you need to do. But that's what I've been told is how to handle your subpoenas for witnesses. You're still gonna put the court address on there, just as if they were to actually show up at court, but you're going to include the Zoom information in the other box.
Do we have any thoughts about if a witness is not available due to technology reasons, what happens then? We proceed with the hearing. Can we use, prior testimony or statements that they made? Judge Yost?
So my rule is ask for permission, not forgiveness. Don't address that the day of the hearing. If you know that's coming up, file your motion, make the parties aware that you're requesting an adjournment for this reason, or you're requesting an accommodation, or can you proceed with witnesses out of order? There's a number of things that can be done, but don't wait until the day of the hearing for that issue to come up, and that'll come up in the etiquette that we're supposed to be testing our systems in advance, making sure that people, as Michelle said, have that, your clients and your witnesses have that technology in advance. You shouldn't test it the day of. That's a bad idea. Also, back to Peter's point about the summonses, I am requiring that the proof of service indicate that not just the notice was served, but the attached Zoom notice was served. I want both on there in order to have a valid proof of service.
Do we have, attorneys, we have some thoughts about how you're going to be communicating with your client who's obviously in a different building with you while the evidentiary hearing is going on?
I think the best way to probably do it is to use your cell phone and communicate with them via phone or text. I know some of the judges are also, I think Judge Yost said that breakout rooms are an option as well. And I think there are pros and cons to using a breakout room to communicate with your client. I would ask to maybe go off the record, and I might call my client rather than a breakout room. But because the judge could pop in, you might not see the notice that pops up to come out or that the breakout session is ending. It just opens it up to all this other technology. And I think that your own phone is probably the most secure way to speak confidentially to your client.
And we've done some testing with the breakout rooms. And I know, Peter, you're about to say something, but after that, Judge Yost, you can share a little bit about how you do the breakout rooms. Peter? I
was just going to mention, when I had my settlement conference with Judge Van Allsburg for my hearing, I talked to him about communicating with my client during the trial, because I think it's very important for us as practitioners to be able to advocate for our client. We need to be able to talk to them, and we need to be able to preserve that attorney-client privilege. And I explained to him how I am very hesitant to give out my cell phone number to some of my clients, because then they call me at Saturday at 8 o'clock and then get mad that I can't do anything for them because the court's closed. And so he said that in certain situations, he would entertain like a motion in limine to allow us to call instead of using the breakout rooms or the conference rooms. And I think that's something that's efficient. Even just doing an email, because again, that's something that your client can still have access to theoretically. But again, that comes into that motion in limine preliminary matters that you want to make sure you're addressing with the judge, either at that settlement conference or pre-trial conference if your judge has one, or if you do not, either emailing the judge's clerk ahead of time about those procedural issues or preliminary matters, and obviously CCing the other side, because I'm sure they probably have the same similar questions, just so again, back to Judge Yost's point, not trying to address these at the day of the hearing.
Judge Yost?
So one of the things that we've brought up is how long these Zoom hearings are taking, right? The more you use the breakout rooms, the longer the hearings are taking, because we have to wait for somebody to pause. If you can text your client while we're going, like you would normally whisper and write on a pad of paper, obviously it's going to go faster. So one of the ideas that I had been submitted, I kind of ran through Peter's issues that he had raised in our practice sessions, and that was the issue of the phone number. I can understand why people don't want to give out their personal cell phone number to their clients, especially depending on the nature of your client. So maybe you get a burn phone, you get a phone that is separate or aligned with different technology, where they have you have a separate phone for your clients to call in on or do this type of text messaging. Another thing with the time issue is, and having these breakout rooms, the only one that likes change is a baby with a wet diaper, but frankly, all of us are gonna have a lot of change now, and we're not gonna like it. So I think something that we're going to have to accept is we're going to have to start using technology more and more. I think as we do more of these hearings, I feel that these breakout rooms are very secure. I've tested them. I've tested them with staff. We tested them again in our practice session. You've got to count on the ethics of your judge. No one should be sitting in this seat if they are not honorable and not willing to not come into a private conversation. Judges moving into those rooms have risk of being charged with ex parte communication. They're simply not going to risk that. So I think you can be confident that if a judge places you in a breakout room, that you are set in the breakout room. I am very careful. I set up my settings and then I go through them and I say, okay, these 2 people are going to be in breakout room 1. These people are in breakout room 2. These people are in breakout room 3. I open all the breakout rooms and I tell them, you're going to get a message from me shortly before I close them. And Michelle, maybe you want to cover this because you talked about the messages that came up. I broadcast a message, it's going to close soon. And then I have an automatic timer. Even after I do that, there's 60 seconds after I close it while it winds down before the room actually closes and forces everyone back in the room.
And you can also shorten that time, Judge Yost, if it's too long.
You can lengthen it, you can shorten it, yes.
So I wanted to talk a little bit about the chat function because at one point, I think the thinking was, well, you could use the chat function to have a private conversation between the attorney and the client, which is true. But it occurred to us yesterday when we were talking as a group that if you have potentially in like a custody case, the mom and the dad could be privately messaging each other and maybe in a harassing way. So I'm a little bit reluctant, especially if it's a high conflict situation. If it's not a high conflict situation, maybe that's not going to be a problem. But there is the opportunity, I think, for private chats that could be harassing that would never happen in the courtroom because they're sitting at different tables with their attorneys in between. So I just want to caution everybody to remember that if chat is available, great, the attorney can chat with their client, but it also opens the door to other people who are in the room chatting with each other. So it just concerned me a little bit. Now, I want to make sure we have enough time to cover the actual conduct of the evidentiary hearing. So let's go ahead and move to that. And I know we have a lot of questions. One question had to do with recording. And part of the question was whether the people who are attending can record. I believe, and somebody is out there can tell me I'm wrong, but I believe that only the host can record. So that would prevent, for example, one of the witnesses or a party or an attorney recording it, at least through the Zoom function. And if anybody knows differently, feel free to raise your hand. Moving to, using the waiting room. Let's talk, one of our panelists, Michelle, perhaps, do you want to talk about the use of the waiting room for purposes of having the judges talk to the attorneys first while the clients and or witnesses are quote unquote outside the room?
That's a good way for the judges to speak to the attorneys first when they first come into the room and you're starting the hearing. I understand that the host can move somebody back into the waiting room and bring them back as well. And that when people are in a waiting room, they can't see each other or talk to each other. So even if you have both parties in the waiting room together and your witnesses there, they are not able to talk to each other. As opposed to if they were all in one breakout room. And the other option is to put the parties in different breakout rooms if the judge wants to speak only to counsel.
Right, and we also have the issue with a lot of domestic violence situations. You wouldn't want to have 2 parties in the same room. You want to protect everybody and not even having a chance for anything to happen verbally, or even an allegation, even a false allegation, I guess, could possibly happen as well. And so we have clients who are going to be there. I'm other than when there's maybe in-chambers conference. So let's talk about in-chambers conferences and what's the client going to be doing at that time?
I think that's where the breakout room can be helpful. Or either you have to put the parties into separate breakout rooms or put them back into the waiting room. You can't leave them together and have the judge and counsel go off into a separate breakout room, because then you'd be leaving the parties together in the same room.
And Judge Yost, what would you be doing? Would you pause the YouTube video while you go to a breakout room to talk to the attorneys?
Absolutely. So I have a double set of security on that. The video that you're seeing today is not the actual video that you would see in my hearings. You would actually see more of my bench. You would actually see my bailiff. So the way our systems run is my Polycom machine calls into the Zoom. So you will actually see 3 parties for my hearings. You'll see my bailiff, who's my co-host, so she can let people in and out. And that's a good point. You should keep track of your clients, because if for some reason their technology is bad and they bump out, we have to watch and make sure they come back in. So you should make sure your client's there. Keep an eye and make sure they didn't fall out of the room. The second thing is that we have myself, but my bench computer does not have volume and it does not have video. So you just see a, you know, airbrushed picture of me with good hair. The last one is the one that is the Polycom, and it's from quite a distance, but it allows you to see more of the full courtroom, get more of a full courtroom experience. The benefit of me doing it that way is I can record both through Zoom and JAVS, which ensures for appellate purposes, you'll like this, Ms. Speaker, that I am able to zone in on one person talking. So Zoom records on just the person talking, where the audio in the courtroom picks up all those extra sounds and anyone that doesn't have their mute on, that drops their glass, that kind of thing. The last point is that, most importantly, I can mute the courtroom and I can shut off the video in the courtroom. So even if somehow the live feed from the live YouTube didn't get shut off, you wouldn't have video or sound anyway because I shut it off in the courtroom. So we do go in and shut off the Zoom, but we also shut off the volume and the video for the courtroom through the Polycom machine. So we have a double security there to make sure that nothing that isn't supposed to be public isn't going live on YouTube.
Peter, could we talk for a minute about, you know, the introduction of exhibits? I know you did a share screen with us already, and I know Judge Yost has procedures for her courtroom, but do you have any, share your thoughts about how attorney might be introducing exhibits actually during the course of the evidentiary hearing? Even
Absolutely.
let's just assume it's one, let's just assume it's a joint exhibit that's been approved already.
Sure.
To make it easier.
So I think this kind of ties into one of the key points I wanted to mention about earlier when we were talking about keeping an eye on the client and making sure that they're there. So you always want to make sure, and this is kind of one of the things that you and I talked about initially, you know, weeks ago, was preserving the record. And so we want to make sure that not only our clients, if they fall out, that we get them back into the hearing as quickly as possible, but we want to make sure that everybody can hear and can see everything that's going on. So in my first questions that I'm usually asking every single witness is, have you been able to hear everything? Have you been able to see everything? Has there been any issues? So that way they can testify to that, especially if it's your client, about what's been going on. When it comes to the exhibit, my understanding is that the court is the only one that's going to be sharing screen. As we already talked about earlier, if we allow everybody to share screens, then we have the risk that an upset spouse is going to have some doodle of some horrific thing and can just flash it up on the screen, or could just start clicking and showing inappropriate photos or whatever, just to get a rise from their soon-to-be ex-spouse, or to just cause problems because that's who they are. So my understanding is one of the other reasons why we are going to be submitting all of these exhibits ahead of time is because the court's going to be the one controlling about how they're going to be shared. And so you're still going to have to do that same foundational type questions when you have your exhibits coming in. And I always remember from my law school days, it's mark it, shark it, take it to your testifier, make them your identifier. It's a stupid rhyme, but I remember it to this day, 12 plus years later. And so you're going to say, you're going to have your exhibit marked, you're going to read that into the record. This is D1, blah, 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 blah. And you want to make sure everybody can see it, because when you've marked it, now you're sharking it. So you're going to say, opposing counsel, do you see the exhibit that's now on the screen? And you want to get that confirmation on the record so that way they can't come back later and say, I had no idea what was going on, or I don't know. And you could even go to the next step and can say, this is a replica of the exhibit that we stipulated to before, or this is a replica of the exhibit that was submitted to the court back on whatever date you sent the email. And that's especially important if it's multiple pages, because again, how much time are they going to have to siphon through those pages as it's being shown on the screen? And so then the next step is you're going to make, you marked it, you sharked it, take it to your testifier. So whoever your witness is that you need to get the foundational stuff set in, you're going to be asking that same line of questions. Do you see the document? How is it? You know, the same foundational questions that you would ask in a regular hearing, you still have to do in the Zoom hearing, unless of course it's been stipulated to. And then after you've done that, then you're just going to ask it for its admission again, unless it's already been admitted per stipulation.
And Michelle, can you address the hypothetical of, you know, you have all your exhibits prepared, and then somebody's on the stand and you realize that now you have to cross-examine them on something that you weren't expecting them to say, and you have a document that has not previously been shared because you didn't know you were going to need this document. Do you want to address that situation?
So I think that's one of the issues that you need to address with the court prior to the start of your hearing. And there are a few ways, I think, to go about it, depending on the judge and how they want to proceed. You can work with the judge to create an email address if something comes up and you say, Your Honor, I have an exhibit. I have something I would like to show the witness. I'm going to email it to you right now. And then, of course, there'll be a pause and delay until the judge is able to pull it up on his or her screen. Or the judge can make you a co-host. And I think that that should work to allow you to share your screen just for that moment, if the court's comfortable with that. But it needs to be, I think all of this has to be thought about in advance.
And again, I think that comes back to what we talked about earlier about there is a lot more preparation for a Zoom hearing than your regular hearing. Whereas before you'll go in with binders, you will just, oh, I remember that was in the, chemical bank statement back in here, and you can find that very quickly. Here, it's not something that you could just take that physical form. You need to have it ready, electronic, ready to go. And so either A, you're going to need to, and a lot of times we know, okay, this is probably going to be an issue that's going to come up, or this is going to be a hot button thing. I should kind of be prepared in case this comes up and have whatever that stack of stuff is saved in as a PDF ready to go if you need it. So it does take that extra thinking 3 steps ahead of what's going on, more so in a Zoom hearing than it is going to be on a regular trial.
Judge Yost, did you want to add anything to that exhibit?
Just that, again, reach out to your court. If they haven't sent you procedures for exhibits, reach out and make sure. I know that Peter talked about Judge Van Allsburg's process and even showed it on the screen. I had a conversation with him as early as this morning that he may be tweaking that process. They've talked about using Dropbox or using some other form. This is new to all of us. We're faking it until we make it, right? We're all trying new things and we're doing our best to come up with best practices. With myself, I list in my orders every exhibit that was admitted. I do a lot of abuse and neglect hearings, so I find that's helpful. So I type those out. So one of the things I require is that you submit your typed list of proposed exhibits in advance. Why? It helps my bailiff. So I either require that the parties do a group email with everyone, so there's no ex parte communication regarding stipulated 2 exhibits, and they provide those to the court, or they provide proposed exhibits on a flash drive or something to that effect to my bailiff, and we have ways to get that in our courthouse so that I can have those ready, and then my bailiff will be sharing and putting those up on the screen. So she'll have them already on her desktop, and if you say, bailiff, may I have exhibit 36, she'll have it pre-marked as 36 and show it up on the screen. One of the things I wanted to cover is security, like the Zoom bombing. We were all really, concerned about that very early on. I see some of you have screen backgrounds. We're not allowing that, or at least most judges I know will not allow you to look like you're sitting on the beach. So plan on that being blocked, and whatever's behind you is showing. There's multiple reasons for that. One is that allows an easier access for security to put something inappropriate in. The second is, and I think Peter brought this up during our trial, if you move your hand, you may not be able to see it. You may not be able to see other people behind you that are in the room. So it doesn't give the court a proper view of the witness. So I personally, even as an attorney, I would not, if your judge lets those things happen, I would say, no, Your Honor, I'm going to object to, somebody looking like they're sitting on the beach. It's inappropriate for a courtroom. We want to see their actual background and surroundings and where they are to properly evaluate that environment. I think that's really important. And then the other thing is just, like Peter had a good process from Judge Van Allsburg. How do you want exhibits admitted? I think that's really important so that we have a consistent method in which we can see how things are coming in.
So I'm going to call on Susan Murphy, who's in the audience today. She had a question about using a document camera. So I wanted you to elaborate on that because I'm not sure I can imagine exactly how that would work. Susan? Of course, as soon as I call, oh, there she is.
Am I there? Am I there?
Yeah.
I use a document camera for my online classes, and so I was trying to figure out, of course, I deal more with in pro per litigants. So I'm not going to have the convenience of, you know.
Oops, she's stalled out.
Am I out? Did you lose me?
You're back.
Okay. So I was just wondering if anybody had tried a document camera yet for displaying purposes rather than worrying about, you know, if it's sent to the judge or not sent to the judge. I'm kind of wrestling with whether I wanted to PDF everything or have the parties, you know, send it in hard copy and then just use a document camera for them to both see at the same time.
I guess I want to make sure I understand. Maybe I don't know what a document camera is. Is it not?
Do you know what an Elmo is? So it's the
red one.
What'd you say?
I said only the red one.
Oh, you only know the red Elmo. So it's just a projector, if you will. It acts like a projector where you face down the camera piece down to the desk, and then you slide the document in front, you know, underneath it, and it broadcasts
onto
screen. The.
Oops, we lost Susan again. Okay, now that actually helped me because I wasn't exactly sure what that was.
In a live classroom, it just goes up on the wall.
Yeah.
In this scenario, it goes up onto the screen.
Have you done it on a screen before?
I have not tried it on the screen yet. That's why I'm asking if anybody's tried it yet, because I have some local attorneys that are going to play with me next week, because I have an evidentiary coming up with some impropers with, you know, over 100 documents.
Where are you, Susan? What county are you in?
Jackson.
Okay. Judge Yost, I would like your feedback, because I know your procedure right now is to be the one to control the documents. I mean, it seems to put a very big burden on the judges to have to do all this. Do you have any thoughts about other alternatives? I mean, obviously we're all...
Unless there is absolutely no other way, I do not want my staff touching paper. I don't know how long COVID stays on paper right now. We've heard 3 days, we've heard 6 days, we've heard 12 days. I don't want my staff touching any more mail or paper. We've bought as much Lysol as we can find in the stores, and there's only so much you can spray down without having an asthma attack. So I am trying to do everything electronically. I'll be honest, most pro-pers that I see don't know how to get a document into evidence anyway. Some of them do, some of them don't, but it's really hard for them to lay those foundations. If they need to send it in and that's the only way we could do it, I think that we're going to have to make some accommodations. But clearly my preference would be the process that I discussed, at least at this point, until we can determine that security's there and there's not another way to prevent the Zoom bombing, as they call it, or inappropriate information. That's going to be on myself and my bailiff.
One question, and this could be for Peter or Michelle if they know, but anybody else that might know, is there a way to allow the share screen function only? Like, could I pick 2 people who can share a screen, or is it just host or everybody? And those are the only 2 choices.
If you make someone a co-host, then they can share the screen.
Okay.
And it depends how your settings are set up. So if you go into the chat into participants.
But a judge is not necessarily going to want to make attorneys co-host with her.
Right.
They do all
well, you can do it temporarily. You can do it for 5 minutes.
Oh, okay. Okay.
The problem is though, Michelle, I think we have a situation where you can only have 1 co-host at a time.
Right. It depends on the settings.
So in my courtroom, that would not work because my co-host is my bailiff, and I need to make sure my bailiff is up controlling things, because frankly, I could pick up the screen and show you, I'm running 3 computers at any one time. I've got my electronic file on one, I've got my Zoom on the other, I've got my legal research and my tabs for case law on another. So I don't have much of an ability to pay attention if somebody falls out of a room, and my bailiff has to keep track of that. And as co-counsel, I don't know if I want the other side being able to host and people, and you know, that's a little dicey for me. So at this point, I'm not comfortable making someone or kicking my bailiff out as co-host and having someone else be co-host.
So we're running out of time, but I wanted to make sure we addressed a topic that comes up in a lot of our cases. What do we do about the child interview when we're all unable to come to the courthouse? Has anybody had a trial court meet with the child since the shutdown, or do you have any thoughts about how that might happen in the next couple of months?
So my case that was set for trial, a friend of the court actually did the interview with the children via Zoom. And so the interesting fact with my case is the parties are still living at home. So if either parent was eavesdropping or in the room, the other parent theoretically would be tattling on the other parent. But that's still, again, that conversation that you want to make sure you're having with your client ahead of time, is making sure that they're prepared for how that is going to happen, and making sure that they understand that they shouldn't be a part of that conversation because they don't want to make it appear that they're tainting the well or causing some impropriety going along, which kind of goes to one of the points I wanted to make from Judge Yost's earlier comment about not allowing backgrounds in for Zoom. And this goes to another point as attorneys to raise for their objection, is that background could be concealing somebody else. So there could be someone else back there whispering answers to the potential witness that you now don't know if it's really a legitimate response or something that's been influenced by that person. I have one other tip, if that's okay to me to sneak in. I know you had a specific question, Lisa. Is that okay?
Yeah, go ahead.
So I wanted to touch base back on with exhibits. And I think it's one thing for, again, from an appellate purpose, is you need to make sure if it's not your exhibit, that you really are taking the time to make sure that what is being displayed and admitted to the court is what either A, was stipulated to, or B, what was disclosed either through your discovery questions that you asked during the leading up to the case, or what was disclosed at the preliminary conference, or what was ever disclosed in your trial brief that was submitted to the court. And I think it's important. I know we've talked about how these Zoom trials might go a little bit longer than normal, but it is important, even if it does take an extra minute, to review that document and make sure that it is what was submitted, because it's so easy to see how things could be submitted electronically and you thought it had 11 pages and now there's 10, or now there's 12. Where did that other page go, and why do we have this other page there? So I just give that as a practice tip. I know we're always, beads of sweat coming down. We're on the, the gun's being pulled, we're on the trigger. It's okay to take that extra moment to make sure that what is being submitted is accurate and what is supposed to be submitted.
And Shelley Kester asked a question on the chat quite early in this about what do you do if you have a witness that you really want, or a party that you really want the judge to see their demeanor. I think my answer would be, you're going to have to ask the court to adjourn your Zoom evidentiary hearing, because if that's really critical to your case, then you're not going to be able to do it by Zoom, and you're going to have to hope that the court will be willing to delay. Judge Yost, do you have any other comment about that?
So the SCAO has directed us that parties do not have a right to object to a Zoom hearing in and of itself. You have to provide good cause. So my strong suggestion is, if you truly believe that's the case, again, ask for permission, not forgiveness. So in advance, notify the court that you believe you have an issue and file your motion indicating that you want it adjourned, why you believe this is important in this case, and then the judge can rule on it. Back to Peter's comments about the background, I see some people are blacked out today. You need to find out, if you don't intend to show yourself via video, is the judge going to allow you to be blacked out? Because again, how do I observe someone's demeanor? I think I can observe someone's demeanor pretty well on Zoom, because I frankly Zoom the witness in. I can probably see more of their facial expressions and their demeanor than I can when they're sitting across the room from me. So I think I can actually see more, not less, when the camera, and you should warn your clients about that, right? Because we can literally see the beads of sweat dropping off their head now, zooming in on them. But that's something to think about. The other thing that I wanted to cover in regards to the child interviews, I was talking to referee Murphy earlier today via email. I'm very hesitant regarding child interviews for the reasons Peter stated, but we did come up with a couple of maybe suggestions if you had a case that really needed resolution. And I think one of those was referee Murphy talked about, could you take a walk around the courthouse with the kid? Could you take a walk outside, keep more than 6 feet apart, both of you have masks on, and have a little chat while you walk around? Potentially, that's a good idea. Another idea, for those who have courtrooms or courts that are kind of open, like I have the ability to order that the doors be open to allow someone in. So like for a child witness, I have a courtroom, I'm lucky in this respect, I have a courtroom with a polycom that's hooked to another courtroom with a polycom. So I could put the child in the polycom room and we could talk through polycom, but I would know they were in a secured environment where no one else could get to them. The last is, what about the counselor's office? If the child has a counselor, does the counselor have a room? The child goes to their normal counseling appointment. That's a safe environment. And you ensure with the counselor that it's a secured room. And then you interview the child via video from the counselor's office. Those are some things I might entertain, but it would have to be a good setting. Otherwise, I'm pretty uncomfortable with that. The last thing that I want attorneys to think about, if I can throw an issue in real quick, we've talked about how long are these taking. We need to think about billing. How do you bill the extra time that a Zoom hearing takes? Does that make a difference in what you're charging clients? And that's something that I think attorneys need to think about, because I think bills are going to go up as the amount of time goes up in preparation, time to conduct the hearings, things like that. And again, test and practice is important. I conducted, how I learned a lot of the things, I actually did a mock trial with some school children, some 8th graders, and most of the bugs in my system, I worked out during a mock trial with 8th graders. So there's a lot of schools that need help right now with ideas for their kids. You can get in and talk to fellow attorneys. I would encourage you to get on, play with, and test the system.
Michelle, I think you had a final thought you wanted to share.
Just following up on what Judge Yost was just saying in terms of videos being hidden, that's another thing to think about. Should attorneys and should the clients be on mute during the hearing? And I mean, I would think not, because it should be just as if you were in the courtroom where if you reacted, somebody said something, witness gave an answer to a question and your client had some large outburst, that should be audible to everyone, just like it would have been.
Good
but
point.
We have the ability to mute ourselves.
Can I add one last thought of wisdom from my perspective?
Yeah.
I think what's going to happen going forward is scheduling orders and discovery is going to become so much more important because we need to rely on those scheduling orders telling us when we're supposed to be disclosing exhibits, disclosing witnesses, and that's something as practitioners we can hold the other side accountable to and use as an offensive to say, look, I have to be prepared just like you have to be prepared. You were ordered on this day to disclose it. You didn't disclose X, Y, and Z. X, Y, and Z should not be coming in. And so I think, again, when we have our discovery just got revamped and we have all of the mandatory disclosures that are a part of our new system, the few things that aren't part of discovery is the basic questions. And I ask this in every single interrogatory and request for production that I send out to this day, regardless of what type of hearing. Tell me who your expert witness is, tell me who your lay witness is, and tell me what documents you intend to use as an exhibit. And even if the client or the other side doesn't know it that early in the case, at least it's preserved it, so that way I can tell the court, I've been asking for this since either when the case started to give additional argument to why something shouldn't be excluded that is being tried to brought in at the last minute.
Thank you all. Judge Yost.
I'm sorry, but one more thing I wanted to bring up that I do think is important. Our test yesterday showed that you can screenshot exhibits if you push your control and print. So you need to be careful if you're putting information or you're having an exhibit that does have confidential information. Be careful of that being on a screen, because somebody can take a picture on YouTube and somebody can screenshot, and you need to be careful of that.
Oh boy. Okay, that opened up a whole can of worms. I think we have to come back into the data. Consider those. Thank you all for joining us today, and especially to our 3 wonderful panelists. I really appreciate you sharing your insights and hope you all have a great afternoon. I'm going to stop
Thanks,
the
Lisa.
recording now.
Thank you, Lisa.
Thank you.